virtually everyone in the constitutionalist community senses that the Social Security number is far more than a device that allows government to track us and invade our privacy. It is one of the primary instruments by which we surrender our inalienable rights and become government subjects rather than collective sovereigns. A number of strategies have been proposed to revoke our Social Security numbers and regain our inalienable rights. Some of these strategies seem workable, others unlikely. But usually, the decision to revoke one's Social Security number is compromised by our need for bank accounts. Yes, I may be able to free myself from the political disability of Social Security, but how can I stay in business if banks won't open accounts without Social Security numbers? In other words, what good does it do me to regain my freedom if I can't cash any checks and am thereby relegated to a subsistence standard of living? Our conflicting needs to a bank account and to be free are so onerous and fundamental that a solution to the banking without SSN problem is very nearly the constitutionalist holy grail. On March 14, 1999, I received the following email from J.D. Kingston, a retired businessman and retired judge, concerning the mandatory use of Social Security numbers to secure bank accounts. Those of you who are interested in banking without Social Security numbers should find Mr. Kingston's opinions illuminating. Dear Mr. Alfred, you and your readers may be interested in following this series of emails. In mid-June AD 1998, I received a postcard from United Community Bank, 2100 FM 407, Highland Village, Texas, 75077. The postcard was an invitation for me to join us for our opening and dedication. They were obviously a new bank looking for some business. Since the postcard included UCB's email address, I sent them an email informing them that due to my sincere and truly held scriptural beliefs, I did not possess a Social Security number, and then asked them if they would accommodate me with a non-interest-bearing account. The following are a series of emails between the bank representative, Rick Schumach, and myself, J. Kingston. June 25, 1998. Dear Mr. Kingston, thank you for your interest in our bank. Though we are a new bank, we're staffed with professionals with many years of experience. The services you made reference to are services that we do offer. However, by regulation, we are required to have local forms of identification, and an SSI number is not optional. While we respect your very strong convictions, we unfortunately must comply with the regulatory requirements. Sincerely, Rick Schumach, United Community Bank, National Association member, FDIC. June 25, 1998. Dear Rick, thank you for your prompt reply. In your reply, you stated that, by regulation, we are required to have local forms of identification, and an SSI number is not optional. I was totally unaware of that. Hope I didn't cause you any inconvenience. By the way, would you be so kind as to give me the citation of the regulation of which you speak? Thanks again for your time. Respectfully, J.D. Kingston. June 27, 1998. Dear Mr. Kingston, I would be happy to provide you the regulation reference for the requirements of the tax identification number. The following are Federal Register references: 37 FR 13279, 37 FR 26517, Title 26, Section 6109 of the Internal Revenue Code, and 38 FR 3341, as well as 38 FR 32336. Sincerely, Rick Schumach. June 28, 1998. Dear Rick, thank you once again for your prompt reply to my request, and a banker answering email on Saturday. This indicates that the material printed in your brochure is not merely just more propaganda put out by business, but is the absolute truth. I appreciate you. Respectfully, J.D. Kingston. July 2nd, 1998. Dear Mr. Kingston, thank you for your kind words. Yes, we do work on Saturdays. As a community bank, we are here when the customer needs access to banking services. Have a good day. Rick Schumach. Postscript. What line of work are you in? July 5th, 1998. Dear Rick, it's nice to see that some banks are concerned with their customers. Too few businesses today seem to forget that it's their customers who allow the bills to be paid. You're to be commended. There's an old analogy about the railroads. They used to flourish. That's when they thought that they were in the people business. They moved people and people's commodities. Then one day, the big shots decided that they were not in the people business, but in the railroad business. The rest is history. I'm a retired businessman and retired judge. My wife and I travel 99% of the time, and we would like to make Texas our home base. Hence, our interest in your bank. We're the kind of people who like to support the little guy, the mom and pop stores, and the new kid on the block, so to speak. We actually have a bank now who doesn't require a TIN from us, and I guess we'll have to stay with them. If you have any age under your belt, I'm 56, you probably know that bureaucrats never pass a statute or regulation that doesn't contain a loophole. I'd be happy to share the loophole to Title 26 United States Code 6109 with you if you have any interest. Good luck with your bank, and to you personally, J.D. Kingston. July 6, 1998. Always interested in learning. What is the loophole in Title 26 United States Code 6109? Rick Schumach. July 12, 1998. Regarding Title 26 United States Code subsection 6109, Part 1. Dear Rick, you would ask. Sorry for the delay. Just got back from a 2-week trip. Had a great time. Supposed to leave again toward the end of the month. Hope I have enough time to satisfactorily answer your question before we have to leave. Rather than write a 10-page email, which is unnecessarily cumbersome and unwieldy, I will split the answer to your question into parts, this being part 1. I'll try to be brief, but that always is impossible when trying to explain a convoluted law. For example, Title 26 United States Code 6109 is comprised of subsections A through H, as well as many subsections. The portion of Title 26 United States Code 6109 to which you referred is Title 26 United States Code 6109 A3, which is titled Furnishing Number of Another Person. It states that any person, in other words, bank, which is an artificial person under the law, any person required under the authority of this title to make a return, statement, or other document with respect to another person, in other words, your customer, shall request, notice the word request here. Notice that Congress did not use a word like demand or require, but they used the word request. Shall request from such other person and shall include in any such return, statement, or other document such identifying number as may be prescribed for securing proper identification of such other person. The word request was used here, so this section would be found compatible with a myriad of other laws, including, but not limited to, the Privacy Act. If a word like demand or require were used in this section, Congress ran the risk of having this section struck down by a court of law. For a company to comply with Title 26 United States Code 6109A3, said company must merely request an identification number from a customer or an employee, but only if said company is required by law to make a return, statement, or other documents. This return requirement would include virtually all corporations, most partnerships, and many sole proprietorships. Pursuant to this section, a company is required to request a number. The company is not required to receive a number, nor is the customer required to give a number. The bad news is that if you are a company required to file a return and do not include all information, that includes identifying numbers for each of your customers, on the forms you send to an agency of government, pursuant to Title 26 United States Code 6721 and 6722, you can be fined $250. The good news is that there is a loophole for each of those sections also. I'll go into more detail if you so desire. In other words, if you're still interested in learning. In a subsequent part, perhaps part 2, which will follow when time allows. Respectfully, J.D. Kingston. July 12, 1998. Thanks for the info. Keep it coming. Have a good day. Rick Schumach. July 19, 1998, regarding Title 26, United States Code 6109, Part 2. I've studied a little history, and it seems that mankind has had an affinity for sleeping and eating for some 6,000 years now. Guess it will always be with us. It's admirable to note that you place spending time with your family in the same category. Your previous postscript reminds me of something my father told me when I was 17 years old. He said, "Son, you can be a success in any endeavor you choose if every day you will commit to working half a day, and it really doesn't matter which 12 hours it is." On to the subject matter at hand. In Part 1, we learned that, pursuant to Title 26 United States Code 6109, a company is required to request an identifying number from a customer/employee, but a company is not required to obtain an identifying number. Now, suppose you have a customer with a non-interest bearing account and it's time to file a report with the banking authorities or some other entity. Suppose you enter the person's name on the report and leave blank the corresponding box that asks for that person's identifying number. Now, what happens? Title 26 United States Code 6721 is titled Failure to File Correct Information Returns. Emphasis added. Leaving off a number that you never obtained does not make the return incorrect. Title 26 United States Code 6721A. Imposition of penalty. 1. In general. In the case of a failure described in paragraph A2 below, by any person with respect to an information return, such person shall pay a penalty of $250 for each return with respect to which such a failure occurs, but the total amount imposed on such person for all such failures during any calendar year shall not exceed $3 million. Title 26, United States Code 6721A2. Failure subject to penalty. For purposes of paragraph 1, the failure described in this paragraph are A. Any failure to file an information return with the Secretary on or before the required filing date, and B. Any failure to include all the information required to be shown on the return or the inclusion of incorrect information. So, if a company is required under Title 26 United States Code 6721A2A by its regulatory authorities to include information such as an identifying number on a return, and it fails to do so, or makes an innocent mistake by the inclusion of incorrect information, the company can be fined $250. See Title 26 United States Code 6721A1. For each failure, but said fine shall not exceed $3 million. Whoa. Title 26 United States Code 6721E. Penalty in case of intentional disregard. If one or more failures described in Title 26 United States Code 6721A2 are due to intentional disregard, emphasis added, of the filing requirement or the correct information reporting requirement, then with respect to each such failure, the penalty imposed under subsection 26 U.S.C. 6721A shall be $500. E3. In the case of any penalty determined under paragraph 26, United States Code 6721-2 and 6121E3, A, the $3 million limitation under 26 U.S.C. 6721A1 shall not apply. So now, if you admit an identifying number with intentional disregard per 26 U.S.C. 6721E, your fine or penalty is increased from $250 to $500 per occurrence. The maximum $3 million is lifted, and you may now be fined an infinite amount. It's no wonder companies don't request a number. They see these statutes and they demand a number. Who in their right mind would subject their company to such huge fines and still expect to keep their job so they can sleep, eat, see my family, etc.? Sounds pretty grim so far. I told you there was good news too. Maybe we'll get to that next time. Keep balancing the customer service with quality family time. Wish I would have done better. Respectfully, J.D. Kingston. July 25th, 1998. Title 26, USC 6109, Part 3. In Part 2, we learned that any person who is required to submit a report that includes provisions for a tax identification number, or EIN number, employer's identification number, or SSN, and omits that information is subject to a fine of $250 per occurrence. But said fine shall not exceed $3 million in any year. Now, the good news, also known as the truth. Title 26 USC 6724 is titled Waiver, Definitions and Special Rules. 6724A, Reasonable Cause Waiver. No penalty shall be imposed under this part with respect to any failure if it is shown that such failure is due to reasonable cause and not to willful neglect. The $250 penalty described and imposed in 26 U.S.C. 6721A1 will not be imposed if your omission was due to reasonable cause. Do you suppose that your failure to supply a number of a customer, who in turn failed to supply a number to you because it did not exist, would be considered reasonable cause? If you answered in the affirmative, you'd be correct. Remember the term shall request in 26 U.S.C. 6109? If you request a number and your request is denied for whatever reason, you have, in part, satisfied the reasonable cause requirement of 26 U.S.C. 6724A, and no fine/penalty can be imposed pursuant to law. And the next part will examine portions of the Code of Federal Regulations, CFR, that pertain to this subject matter. For your homework, you may study the following two definitions. Code of Federal Regulations. The Code of Federal Regulations is the annual culmination of executive agency regulations published in the Daily Federal Register, combined with regulations issued previously that are still in effect. Divided into 50 titles, each representing a broad subject area, individual volumes of the Code of Federal Regulations are revised at least once each calendar year and issued on a staggered quarterly basis. The Code of Federal Regulations contains the general body of regulatory laws governing practice and procedure before federal administrative agencies. Black's Law Dictionary, 5th edition, pages 233 and 234. Federal Register. The Federal Register, published daily, is the medium for making available to the public federal agency regulations and other legal documents of the executive branch. These documents cover a wide range of government activities. An important function of the Federal Register is that it includes proposed changes, rules, regulations, standards, etc., of governmental agencies. Each proposed change published carries an invitation for any citizen or group to participate in the consideration of the proposed regulation through the submission of written data, views, or arguments, and sometimes by oral presentations. Such regulations and rules as finally approved appear thereafter in the Code of Federal Regulations. Black's Law Dictionary, 5th edition, page 551. Respectfully, J.D. Kingston. July 26, 1998. Subject Title 26, United States Code 6109, Part 4. Dear Rick, in Part 3, we learned that no penalty can be imposed for failing to include a tax identification number on a report if your failure was due to reasonable cause. The Code of Regulations, CFR, sheds considerably more light on the subject. Before we look at the CFR in detail, let's examine why it exists. The legislative branch of government is the only branch who possesses legislative, lawmaking powers. The executive and judicial branch of government possesses no legislative powers. When the legislature passes a bill and the president signs it, the bill then becomes law, and it is recorded in a volume of books called the United States Statutes at Large. They, the laws, are recorded in chronological sequence. If you want to read a law that was passed, you would have to know when it was passed so you could find it. As you can imagine, this could be anywhere from cumbersome to impossible. To remedy the problem of finding laws, the laws have been codified or sorted by subject matter. After being codified, they are recorded in a new volume of books called the United States Code. After a law has been passed, it is the responsibility of the executive branch of government to see that the laws are executed properly. When a department of the executive branch of government determines that they are responsible to see that a particular law that was passed is within their authority, they write rules and regulations for their employees to execute that law. The executive department employees must abide by those rules and regulations when executing the law. Laws, statutes at large, passed by the legislature are different from rules and regulations passed by the executive department in order to implement the law. When the executive department writes these rules and regulations, they are required to publish them in the Federal Register. 30 days after publication, the rules and regulations become valid. After becoming valid, they are published in a volume of books known as the Code of Federal Regulations. Of course, the rules and regulations should be compatible with all laws. If they are not, and they are challenged in a court of competent jurisdiction, they risk being struck down as being in contravention of some law. Hope this isn't becoming too boring. And the next part will examine the specific rules and regulations, CFR, that pertains to Title 26 United States Code 6124. Respectfully, J.D. Kingston. July 27, 1998. Thanks for the input. Not boring at all. Rick Schumach. July 30th, 1998. Subject, Title 26, United States Code 6109, Part 5. Dear Rick, thus far we saw that, number 1, a filer must request an identifying number. Number 2, that if the filer omits the number on a required report, the filer may be fined. Number 3, that the fine may be waived under certain, in fact most, circumstances. Number 4, that the Code of Federal Regulations does not contain laws, but only executive agency regulations. And number 5, that the Federal Register is the medium the executive branch uses to disseminate executive agency rules and regulations to the public at large. Title 26, Code of Federal Regulations 301.6724-1, titled Reasonable Cause, goes into great detail to explain how one will not be penalized. Such great length, in fact, it contains about 8,035 words. I won't dwell on all of them here. Was that a sigh of relief I heard? You're probably beginning to see what I meant when I used the phrase convoluted law in a past email. Just as one Code of Federal Regulation could take 2 or 3 or even 4 emails. Title 26 CFR 301.6724-1A is titled Waiver of the Penalty. The penalty for failure to provide information will be waived if it is determined that such failure is due to reasonable cause, to wit, Title 26 CFR 301.6724-1A1 General Rule. The penalty for a failure relating to an information reporting requirement, as defined in paragraph J of this section, is waived if the failure is due to reasonable cause and is not due to willful neglect. Emphasis added. Title 26 CFR 301.6724-1C is titled and describes events beyond the filer's, corporation's, control. In other words, if a customer does not provide a SSN as requested because such number does not exist, it would certainly be deemed beyond the filer's control. Title 26 Code of Federal Regulations 301.6724-1C6 is titled and describes actions of the payee, customer, or any other person. In order to establish reasonable cause under paragraph C1 of this section due to the actions of the payee, emphasis added, or any other person, such as a broker as defined in section 6045C, provided information with respect to the return or payee statement, the filer must show either. To be continued. Kind of like an old Alfred Hitchcock thriller. Respectfully, J.K. August 26, 1998. Subject, Title 26, United States Code 6109, Part 6. We left off last time at 26 CFR 301.6724-1C6, which is titled and describes actions of the payee, in other words, customer, or any other person. In order to establish reasonable cause under paragraph C1 of this section due to actions of the payee, emphasis added, mine, or any other person, such as a broker as defined in section 6045C, provided information with respect to the return or payee statement, the filer must show either 26 CFR 301.6724-1C6I, that the failure resulted from the failure of the payee or any other person required to provide information necessary for the filer to comply with the information reporting requirements to provide information to the filer. Emphasis added, mine. The other either under 2 pertains to incorrect TINs and is not relevant to our discussion. 26 CFR 301.6724-1E talks about acting in a responsible manner, special rules for missing TINs. Title 26 Code of Federal Regulations 301.6724-1E1 in general. A filer that is seeking a waiver for reasonable cause under paragraph C6 of this section will satisfy paragraph D2 of this section with respect to establishing that a failure to include a TIN or an information return resulted from the failure of the payee to provide information to the filer. In other words, a missing TIN. Only if the filer makes the initial and, if required, the annual solicitations described in this paragraph, emphasis added. So if a company failed to include a tax identification number on a return, the penalty will be waived for reasonable cause if the company makes an initial solicitation. And in this case of incorrect TINs, a first annual solicitation and sometimes a second annual solicitation. In the instant case, the first and second annual solicitations are moot since we are not addressing incorrect TINs. So what's a solicitation? Looking again at Black's Law Dictionary, 5th edition, page 1249, we're informed that a solicitation is asking, enticing, urgent request. When do you make the initial solicitation? We find the answer in 26 CFR 301.6724-1E1I, initial solicitation. An initial solicitation for a payee's correct TIN must be made at the time an account is open. The term account includes accounts, relationships, and other transactions. 26 CFR 301.6724 LE12, first annual solicitation, pertains only to incorrect TINs. 26 CFR 301.6724-1E13, second annual solicitation, likewise pertains only to incorrect tax identification numbers. By the way, Rick, if you have any questions as we go along, just jump right in and ask. I promise to keep my answers shorter than the answer to your last question. What is the loophole in Title 26 United States Code 6109? Respectfully, J.K. August 2nd, 1998. Subject read 26 U.S.C. 6109. Part 6. I find this most interesting. However, not having done my research of late on the subject, I believe I recall that my regulatory body has directed that we, as a bank, act assertively to secure the tax identification number, and that without it, we should not proceed with opening a relationship with the tax identification number holder. Hope you are staying cool. Rick Schumacher. August 3rd, 1998. Subject Title 26 United States Code 6109, Part 7. By now, you probably had enough exposure to the law to have guessed that there are exceptions and limitations to the first and second annual requests to correct an incorrect TIN. Most of those exceptions and limitations are beyond the scope of our discussion, and for the sake of brevity, will be avoided. I can't believe I said for the sake of brevity. What is this, Part 7? However, one exception is pertinent. If you do not pay a customer any monies, as will be the case with a non-interest bearing account, you need not to make annual solicitation, to wit, 26 CFR 301.6724-1EL6, Exceptions and Limitations. Part B, An annual solicitation is not required to be made for a year under this paragraph E with respect to an account if no payments are made to the account for such year or if no return as defined in paragraph G of section 301.6721-1 is required to be filed for the account for the year. Emphasis mine. In the next email, we'll try wrapping this up. Respectfully, J.K. August 13th, 1998. Subject 26 U.S.C. 6109, Part 8. Tried to figure out how to stay cool for 30 days. Then it dawned on us. Leave town. Which we promptly did and vowed not to come back until the highs would only be in the low 90s. Now we're wondering why we came back so soon. Where were we? Oh yeah, wrapping this up. What have we learned? Well, we learned that A, you are to request an identifying number from me when you open my non-interest bearing account, 26 U.S.C. 6109A3. B, your request is deemed an initial solicitation, Title 26 Code of Federal Regulations 301.6724-1E1I. C, you cannot be penalized for my actions or lack thereof, 26 CFR 301.6724-1C6, if I don't have a number due to sincere and truly held scriptural beliefs or not, I can't fulfill your request. D, you cannot be penalized for your actions that are due to a reasonable cause, 26 CFR 301.6724-1A1. E, the Code of Federal Regulations does not comprise the law. They merely contain the rules that regulate the executive branch of government. F, the Federal Register does not comprise the law. It merely contains proposed rules that may become part of the Code of Federal Regulations. And G, if it doesn't get any cooler, we're going north again. There are two more codes of which we should be aware. I'll address one of them in my next email, and the other one in my final email. Respectfully, J.K. August 16, 1998. Subject 26 U.S.C. 6109, Part 9. Rest assured, I'm only presenting the following two codes for your information, education, and knowledge. That bears repeating. I'm only presenting the following two codes for your information, education, and knowledge. Section 7A1 of Public Law 93-579, entered at 88 Statutes at Large, 1896, 1909, 1231, and 1974, codified at 5 United States Code 552A, and the note states that it shall be unlawful for any federal, state, or local government agency to deny any individual any right, benefit, or privilege provided by law because of such individual's refusal to disclose his Social Security account number.
What?
However, as a banker, you might say, we're not a federal, state, or local government agency. But if you said that, you'd be wrong. Look at a legal encyclopedia such as American Jurisprudence or Corpus Juris Secundum under agency, and you'll find a myriad of cases that prove the point. Turning once again to Black's Law Dictionary, 5th edition, pages 57 and 58, we find agency. Relationship in which one person, like a corporation, acts for or represents another, like the government, by latter's authority, either in the relationship of principal and agent, master and servant, or employer or proprietor and independent contractor. Cases omitted, parentheses added. Does the bank corporation act by government authority and deduct federal income tax and federal insurance contribution act and turn them over to the principal/master government? Let's see. The relation created by express or implied contract or by law, like a corporate charter, whereby one party, the government, delegates the transaction of some lawful business with more or less discretionary power to another, the corporation, who undertakes to manage the affair and render to him, the government, an account thereof. Cases amended, parentheses added. Or relationship where one person, the government, confides the management of some affair, like collecting taxes, to be transacted on his account to another party, the corporation, or where one party, the corporation, is authorized to do certain acts for or in relation to the rights or property of the other, the government, by means more than tacit permission and involves request, instruction, or command. Cases omitted, parentheses added. The consensual relation existing between two persons by virtue of which one is subject to other's control. Is the corporation subject to the government's control? Agency is the fiduciary relation which results from the manifestation of consent by one person, the government, to another, the corporation, that the other, the corporation, shall act on his, the government's, behalf, and subject to his, the government's, control, and consent by the other, the corporation, so to act. Restatement second, Agency, Section 1, parentheses added. Do you know any corporations with a fiduciary relation? More next and final, hopefully, time. J.K. August 16, 1998. Subject, Title 26, United States Code, subsection 6109, Part 10. Dear Rick, the other law that you need to be aware of is Title 42, United States Code, subsection 1983. But let me repeat again what I stated in my last email. I'm only presenting these two codes for your information, education, and knowledge. Title 42, Section 1983 is titled Civil Action for Deprivation of Rights. It states, every person, not many excluded here, who, under color of any statute, ordinance, regulation, custom, or usage, under color means a deceptive appearance versus that which is real, like a demand versus a request, of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person, not many excluded here either, within the jurisdiction thereof, to the deprivation of any rights, privileges, is using a bank a right, a privilege, or immunities secured by the Constitution and laws, shall be liable to the party injured in an action at law, suit in equity, or other proceeding for redress. For the purposes of this section, any act of Congress applicable exclusively to the District of Columbia shall be considered to be a statute of the District of Columbia, parentheses added. If you knew back in mid-June what you know now, and I informed you that I did not possess a Social Security number due to my true and sincerely held scriptural beliefs, and I asked you if you would accommodate me with a non-interest-bearing checking account, what would your answer have been? Enjoyed writing to you. It keeps me sharp. Looking forward to your reply. God bless you and yours. Respectfully, J.K. September 6, 1998. Subject, Title 26, United States Code, 6109, Part 11. Greetings. Just returned from a 3-week trip. Why is it still hot? My calendar reads September. I must confess that I was somewhat disappointed when I found no reply from you when we returned. Hope all is all right with you. I can only surmise why a reply was not forthcoming. The last time you replied was on October 2nd, 1998. And in that reply you stated, I find this most interesting. However, not having done my research of late on the subject, I believe I recall that my regulatory body has directed that we, as a bank, act assertively to secure the tax identification number, and that without it, we should not proceed with opening a relationship with the tax identification number holder. One other law we should be aware of is 42 United States Code 408A8, which states in pertinent part, whoever compels the disclosure of the Social Security number of any person in violation of the laws of the United States shall be guilty of a felony, and upon conviction thereof shall be fined under Title 18 or imprisoned for not more than 5 years or both. For your own benefit, you may want to make sure that your regulatory body directives are in writing. In the event you can't give me the courtesy of a reply, I understand. Everybody has a boss. I wish you well, my friend. Respectfully, J.K. September 8th, 1998. Sorry, no offense intended. Have been extremely busy and out of pocket. The year 2000 requirements and the regulatory protocol for documenting our preparedness has taken me away from being a banker and yada, yada, yada. We'll reread your last couple of messages and get back with you. Rick Schumacher. Mr. Kingston concluded his email to the anti-shyster writing, I waited 3 weeks and Mr. Schumacher never did keep his word and get back to me. I've since left the area and will not pursue this issue any further with Mr. Schumacher. I will not offer a similar statement to any other bankster at this time. Respectfully submitted, signed, J.K. P.S. If you deem the foregoing worthy to publish, please withhold my address. Thank you.